this administration is profoundly evil in ways that are difficult for Americans to comprehend. We have reached a stage of illegality, immorality, and depravity in a federal administration that no one could have ever thought possible.
Hello, everyone. Welcome to George Conway Explains It All to Sarah. I'm Sarah Longwell, publisher of the Bulwark. And because I'm not a lawyer, I've asked my good friend George Conway to come on and explain the legal news to me. George, what's going on, man?
Hey, JV. Oh, sorry. Oh,
that's like so JV. Rude.
Oh,
rude.
Okay. You're back. Yes.
How was it doing 2 weeks in a row with JVL?
It was, I like JV. No wonder why he's your best friend. I'm upset that I'm not, but it's okay. I can take it.
There's a lot of competition for that best friend slot.
Really, I know.
It's fun for me watching you two together, though.
Yeah,
I like
it's fun. It's like, and we're like very doom and gloom together.
Yeah.
Right?
You are. You guys spin each other into the bad place.
Like we are both Debbie Downers, Donnie and Debbie Downer. I don't know. I mean, it's like, no, the disaster is going to come next week. No, it's going to come tomorrow. No, it's going to come in this afternoon. I mean, that's what we do.
If I might make an observation, actually, maybe we should talk about this a little bit. You were for the longest time, like, I'm the optimist at the Bulwark, but you were like in territory of like, no, we're going to get him. And this, and now,
no, I know.
Now you've crossed over into you were more optimistic than I ever was. And now you're in JVL territory. You you never even stopped in Sarah land where we might be okay if we do the right thing.
Because here's the reason.
Okay.
I had a lot of confidence in the American people. More than you did, because you were actually in Pennsylvania talking to some of the American people. I simply refused to believe that 49% of the public could actually vote for him. I accepted the fact that 47 or 46 would, but I just, had this belief that he just couldn't get over the top and that he had a ceiling, and that was wrong. And I fully admit that was wrong. I mean, that being said, I was not so optimistic that I didn't do things. I didn't write a check to the Democrats for $29,000 because I thought he couldn't win. Right.
That's true.
I didn't do, the psycho pack because I thought he couldn't win. I just thought that, if all of us pitched in, things would turn out just right. Now, the problem is he's back.
Yeah.
And I'm convinced that even if the American people get their act together on him, and they're starting to realize that. I mean, there was this great article, I hate to say great article in Axios, but it was actually a great article in Axios.
No, there was an op-ed in The Atlantic written by me 2 weeks ago about the fact that Americans were starting to turn.
Yes, no, and I think that's great, but the fact of the matter is, for reasons that I'm sure we will get into and that I've gotten into with JV the last couple of weeks while you were on vacation.
I wasn't on vacation. I was working. I had to travel for work.
Oh, sure.
Okay.
No, while I'm pessimistic that I believe that even if things turn around publicly, I don't think they're going to turn around publicly fast enough to prevent some of the bad things that I think are going to happen. And I hope I'm wrong on that. I would like to be 0 for 2 on being wrong. But we'll get into more of that. I have more explication of doom and gloom that probably will come up during the course of our discussion of the illegal, not legal. It used to be legal. It is now illegal news. And
all right, let's get into the actual news of it all, the illegal news of it all. So on Thursday, 2 different federal judges in 2 different cases ordered federal agencies to reinstate tens of thousands of workers with probationary status who had been fired across those 19 agencies, or across 19 separate agencies. A lot of agencies. So it's 2 judges, 2 different cases, 19 agencies. And so these aren't the final decisions in either of these cases, and these terminations may still go into effect, but it is another setback for the administration on this. So why don't you explain, like, what's the primary legal issue in this case? And because I assume agencies can fire people if they want to.
Yes, they can. But the problem is there are rules and laws regarding that. And there were two cases, one in the District of Maryland, which you can see out my window if I rolled it up, and then one in the Northern District of California in San Francisco before a very prominent judge named William Alsup. And the judge in Maryland was named Judge Bednar or Bredar. And basically what the administration did in a whole bunch of agencies was fire en masse the probationary employees. And I don't remember exactly how long you're a probationary employee when you're hired, but you have fewer civil service protections. If you are a civil service probationary employee, they can get rid of you easier. But there are a couple of restrictions. One is if you are fired for cause, even as a probationary employee, they can't do it arbitrarily. They have to do it for cause. They have to have a reason. Like you misled them on your employment application, or you did some completely bad act, and you have to document it. And it has to be individualized. They did not do that because they just fired everybody en masse. They pretend that, oh yes, we made a determination, but that's it's bullshit. And in fact, the judge in the Northern District of California called the firings a sham. That's point one. And even apart from that, there is another way you can fire a bunch of people all at once. And that's called a reduction in force. And right. You can fire civil servants through a reduction in force if, you just run out of money, or just some extraordinary circumstance that says, okay, we just can't use these people anymore. But again, the statute has hoops that you have to go through to document that. And notice that you have to give to various states, in fact, in certain circumstances. And the government did none of that. Okay. And you have to make findings. There has to be a process, a deliberate, rational process. And the government just basically fired people willy-nilly. So they're going to lose that case, but brought by various states and various people who were fired, but both cases. And, it's just amazing. Those are the two biggest, most recent losses because they just happened late yesterday, two of them at once. But it's amazing. I was going through in prepping. I don't normally prep for this because I've been keeping up with it, but I can't keep up with this. And I had made a list of everything I remembered that had happened over the last week or so where they were losing cases. And I came up with this list. Look.
Oh, my goodness.
Like a whole list of all the things that they've lost. And it's crazy just in the past few days, and I probably have missed some.
Did they win any? Did they win any?
The only thing they won, and I have trouble remembering the dates, is they kind of won the case involving the firing of the ethics guy at the department, at the Office of Special Counsel, who is his name is Hampton Dellinger, the son of the famous former Solicitor General, and. Yeah, they were going to lose that case. For a bunch of different reasons, not worth getting into. But they've lost a whole bunch of other things, including some pretty significant stuff. And in just the past few days, I can go through.
And so far, are they abiding by the rulings when they lose in court?
Well, okay, this is the thing that I've been kind of going off on: is when are they going to, if they are going to, and when are they going to just openly defy orders? And they're not at that stage yet. They're at the dog 8-hour homework stage of defying a court, where people sometimes say, oops, judge, oh, we forgot to tell these people. Oh, the government, it just takes a while to send memos through the government. Oh, we didn't understand. Oh, there's a comma there. Oh, that makes a difference. Oh, we thought the comma was over here and we can't, they're playing all sorts of games that are highly annoying to federal judges, and federal judges don't like to hold people in contempt, even when they're even when the judge is being jerked around. What they normally do is they just basically ream out the lawyers and tell them, you better tell your client to get his act together or her act together. But here it's sort of harder because it's the government, and they're dealing with the executive branch. They're dealing with ultimately with the president of the United States. But they're still showing that these judges, not just one or two, but a whole bunch, they're really baring their teeth at some of the lawlessness that's going on. So it's very to that extent, I'm normally Debbie Downer, and I'll give you all the reasons to be Debbie Downer on this stuff. But it's inspiring to see these lawyers litigating these cases and these judges showing no fear. That said, I also have criticisms of a lot of the legal profession, but about how they're dealing with the current circumstance.
Ooh, I've got a whole section on that.
Yeah.
What I was trying to think is like, what was it like to be one of these federal employees, right? Where you're terminated and then the courts are stopping it. Like, kind of how does this work in practice? Like, are they all fired and now they're like, you're not fired, you come back to work and then you work until it goes to another level of judges?
And until that's sort of what's happened. I mean, I was just reading the injunctive relief ordered by the judge, I think in Maryland, and basically says these guys get to go back to work. And, I think what the government is going to end up doing is they're going to try to take it, in the case of the Maryland case, up to the Fourth Circuit to say, this will create chaos. All these people, we've moved their desks and unplugged their computers and it would be irreparable harm. And, I don't think they're necessarily going to win that. On the other hand, these rulings don't say there isn't a way to get rid of people. Okay, they have to create, but basically they can try to do it again with a better record. Why
don't they just do a reduction in force?
Because there are statutory requirements. You have to make certain findings. You have to do it in certain ways. In various, it's a whole bunch of hoops you have to jump through, and you have to give notice to the states, and there's a whole bunch of things I can't even explain it all. I mean, I could read from the opinion, but Congress passed a law that basically said you can do reductions in force, but you got to do A, B, C, D, E, F, and G. And they didn't do any of it. So that's the problem. And what they can, the government, I guess, can try to fix that. But there are a lot of, like, for example, one of the rationales for reduction in force that's allowed under the statute is you don't have the money. It's like, well, they do have the money. They may not have the money next year after the continuing.
Well, yeah, I was going to say Congress appropriated the money for this.
But Congress, right. That's the thing, is that they're going to keep coming back in different ways, and they're going to get sued again, and they're going to keep. This is just the first of many rounds, and that goes to the problems. Some of the problems that leave me a little pessimistic over the medium term to the long term that we can discuss later.
Well, why don't you hit me with that? Like, tell me why you're pessimistic. Just while we're on this particular topic.
Sort of, I think the discussion flows also from another case that I hope we talk about, the Perkins Coie case.
Yes.
But in this case, it's just, here's the problem. Writ large, and I think JV and I talked about this, and I'm going to keep repeating it because it's worth repeating. The problem that we have is ultimately, let's assume they do obey court orders in their half-assed way. Okay, they don't actually go out and give the finger to the courts the way J.D. Vance was suggesting a couple of weeks ago, or 3 weeks ago, that the administration, he says the administration could do, a la Andrew Jackson. The problem is the lawlessness and the disobeying of federal statutes, many federal statutes, this reduction in force statute, the appropriations bills, refusing to spend money that's been appropriated, various constitutional provisions in the Perkins Coie case, we'll get to the First, Fifth, and Sixth Amendments, the Birthright citizenship. They are violating the law. And then, you got the case with the Palestinian student at Columbia, where they're just basically denying due process.
These are all my topics right now. These are all the topics we're going to talk about.
They are violating. It's like, let's see how many violations of manifest violations of federal law we can commit. We're just going to throw it all out there. And the problem is, even if you get enjoined every single time you do that, they can come back and do it again. They just abducted another Columbia student. Or they can come back and say, okay, we jumped through the hoops that you said we had to jump through to do a reduction in force. Here we are. Bye. And then they get sued again, and the judge is going to rule again. No, sorry, you didn't do that. The problem is you have an executive who is charged under Article 2, Section 1 with faithfully executing the laws and the Constitution of the United States. He doesn't want to do it. He wants to violate the laws and the Constitution of the United States. He does not give a flying you-know-what about what the laws and the Constitution of the United States actually says. He thinks he's a king. He said during his first administration, like 5 years ago, he said, Article 2 allows me to do whatever I want. Sorry, that's wrong. It doesn't do that. It says you have to abide by the law. It says you have to faithfully execute the law. He says that the person who saves the nation can do no wrong. He thinks he's above the law. He doesn't care what the law says, which is why I think ultimately he's going to disobey the court orders. But let's leave that aside. The problem with an executive who does that is the proper solution to the problem can't exist in the third branch, the courts, because the courts are not institutionally capable of running the government. We've had this debate before in years past, decades past, Cooley segregation cases or the Yonkers housing case where judges are trying to administer school districts and housing agencies and prisons. Judges can't do it. They're not equipped to do it. They can, they have to try sometimes because they're out there to remedy violations of the laws and the Constitution. But at the end of the day, the courts you can't have 600 plus federal judges trying to run the federal government through litigation when the president is just refusing to do his job, and not only refusing to do his job, basically saying F you to the duties that I have. The correct solution, and this is what made JV laugh, and you guys put it up on the internet, what JV laughing at me, the correct solution that the framers intended was impeachment and removal when a president refuses to do his job.
That would make JVL laugh.
He did laugh. I said, the correct solution is impeachment. And JV just started laughing at me. But that's the problem. We have a supine Article 1 branch where you have a majority of both houses of Congress who absolutely have refused in the past, in prior Congresses, to hold this executive in his prior administration to account. They're refusing to. Even after he left office, they refused to. They let him because, they acquitted him after he launched an insurrection. And they said, never mind, that's okay. We aren't going to do anything about that because he's gone now. And, here we are again. And there's no hope for these guys. They're not going to do it.
That's true.
And you need 2/3, you need a super majority of the Senate. Okay, it's not going to happen. So basically, that's the check that the framers intended. It does not exist as a practical matter, and the judges have no armies. And we go back to the fact that they have to rely actually on the Justice Department to actually enforce their orders. So we're even assuming that Trump doesn't tell the Justice Department to say, nope, don't send the marshals out to hold the secretary of whoever in contempt. You basically are going to end up with endless litigation where the judges are trying to play catch up to violations of law, and they won't be able to do it. And there are other reasons too, when we talk about the Perkins Coie case, why judge, even winning these cases, for in the case of Perkins Coie, even winning these cases doesn't necessarily fix the problem. Because litigation can be great, but it can't save the world.
Right.
And it can't save the country.
Right.
It
cannot all be up to the courts. Yeah.
Correct.
Right. Hold on. So I want to get an ad read in here so that we can move on to some of these other topics. So one of our sponsors today is OneSkin.
Oh, I got my face full of it today. Full of it generally.
You are full of it generally, yeah.
I'm full of it generally, but I am full of OneSkin today.
As the seasons change, so do your skin's needs. Shifts in the weather can lead your skin feeling irritated, tight, and dry, especially if you have sensitive skin or conditions like eczema. Look, baby soft over there.
Oh.
But what if your skincare routine could help calm your skin and reverse the signs of cellular aging at the same time? That looks like what it's doing for you, George. You look younger every time I see you.
I look 20 years younger than we first started this podcast.
That's right. Even though this is aging us.
This is aging us, aging our minds faster than we can ever make up for it. If they have OneSkin for the brain, we need that.
We're gonna crush that.
Yeah.
All right. Well, enter OneSkin, founded by 4 PhD level researchers. OneSkin is the only company with OS1 peptide, the first ingredient scientifically proven to reduce the dysfunctional senescent cells, aka zombie cells, that build up as you age and make you more sensitive to those seasonal symptoms like tight, dry skin, which I totally get. Their products are free from more than 1,500 common irritants and backed by countless lab and clinical studies. Just a few of the reasons they've earned the National Eczema Association seal of approval. Great job.
There's a national... Wait,
I know.
What? There's a what?
The National Eczema Association.
They're against eczema, right? I hope they're against eczema.
Yes, they are.
Okay.
Yes,
good.
even though the seal of acceptance, I don't know what that means, but I think it means eczema is bad.
They're against
combat it.
Eczema is bad. Good. I want to make sure.
Whether you have seasonal sensitivity or year-round irritation, OneSkin soothes and calms your skin while helping it become younger and healthier at the cellular level. For a limited time, you can get an exclusive 15% off your first OneSkin purchase with code AskGeorge when you check out at oneskin.co. George, you and I both love the OneSkin. I keep it on my desk because it is, even though it's like starting to get to be spring, my hands get really dry. I use the stuff on my eyes during the day because I think I'm getting those.
The eye one is really good. The eye one is good. I got so much of this stuff. It's like you can just order it directly from me. I've got so much of this stuff in my bathroom. It's crazy.
Yeah, it's good. But we need it. We love it. Founded and led by an all-women team of skin longevity scientists, OneSkin is
women.
redefining.
We're for women.
Yeah, we like that. Wow, founded and led by an all-women team of skin longevity scientists, OneSkin is redefining the aging process with their proprietary OS1 peptide, the first ingredient proven to help skin look, feel, and behave like its younger self. Get 15% off with code AskGeorge at oneskin.co. That's 15% off oneskin.co with code AskGeorge. After you purchase, they'll ask you where you heard about them. Please support our show and tell them we sent you. Invest in the health and longevity of your skin with OneSkin. Your future self will thank you. Okay. So I don't know whether to do Perkins Coie next or Birthright Citizenship. Dealer's choice. Which one do you want to do?
Do Birthright Citizenship because the Perkins Coie thing is going to get me all wired and you won't be able to shut me up until you turn off the camera. Right.
Okay. All right. So let's do Birthright Citizenship. It already feels to me, I don't know about you, like a million years since Trump issued his executive order banning birthright citizenship, which was on Inauguration Day. No, it hasn't been that long.
Right. We are less than 2 months. We are less than 2 months. It's crazy.
So obviously there was a ton of lawsuits that were filed against that executive order saying it's unconstitutional since
I think there are
pretty clear on this
that's
one.
a lot. Yeah.
And a few different federal judges have issued preliminary injunctions which prevent the executive order from going into effect. And yesterday, the administration filed emergency applications at the Supreme Court in 3 of these cases, asking the court to lift the injunctions. All right.
Not quite.
Oh, wow.
Not quite.
Then tell me more.
I will tell you more. So there are at least 4 cases. There are 2 in the First Circuit, which is kind of New England. The government lost their preliminary injunction against a nationwide, remember that word, put a pin in that word, nationwide preliminary injunction was obtained by the plaintiffs there.
Okay.
There was a case in the Western District of Washington, which was the first, I think, that the government lost, a nationwide, again, emphasis, nationwide preliminary injunction there, issued by an old Reagan judge who basically said, this is just crazy. This is lawless. I mean, he used some very, very harsh language to describe what the government was doing, a conservative judge. And then there's another case in, I think, Maryland. Is it Maryland? Yeah, in the Fourth Circuit, which is this area around D.C., Maryland, Virginia. And there a third nationwide permanent injunction. The government, and there's another case in New Hampshire that has not yet been adjudicated to that scope yet. But in the cases that the government lost, they took those up to the respective circuits, First, Fourth, and Ninth federal U.S. courts of appeals. And those courts denied the government's application for a stay. And now the government filed 3 basically identical applications in each of those cases in which it lost in the Fourth, Ninth, and Fourth, First, Fourth, and Ninth Circuits, to lift the stays, the injunctions only partially. They're not actually saying that the plaintiffs are wrong on the interpretation of the 14th Amendment. What they are saying is these injunctions are overbroad because they don't just apply to the districts in which they came from, these cases came from, or to just to the individuals. They're applying nationwide. And they're making an argument that has actually nothing to do with the Birthright Citizenship Clause, which actually has some merit, and I can give you a brief history of it, that district courts can't enjoin the government in one case across the nation. And this is something that has been a problem in the federal courts for a while, where even by the end of the Biden administration was making a similar argument, or the same argument, in other kinds of cases, because what would happen is, like, the Texas Attorney General, all the right-wing Republican Attorney Generals would bring a case before this one judge in the Eastern District of Texas that they liked, and they would get an injunction against everything they didn't like that the Biden administration was doing. It drove the Biden administration crazy. Why this one judge should get to do this? And now that the shoe is on the other foot, and this happened during the first Trump administration too. They'd get nationwide injunctions when the first Trump administration did illegal stuff. Although, frankly, the first administration of Donald Trump looks like a law-abiding citizen compared to what's the lawlessness going on now. They're arguing basically, okay, you can enjoin your state basically, or your district. I don't know exactly what the scope is, but you can't enjoin us nationwide. And, it's an interesting question about whether or not the Supreme Court's going to bite on that. But the fact of the matter is, if the Supreme Court bites on that on this preliminary round, it doesn't affect the merits of the bullshit argument that the government is making to try to to strip people.
Wait, sorry. So then let me understand.
So see if you can translate that.
Yeah. Are you saying that the Supreme Court would be ruling on not the substance, but Correct. On the technical way in which a district Correct. Court can rule?
Which is right.
And I'm surprised that hasn't happened before. Like, if you say this is a problem, why?
I'll tell you this. One of the things back in 2016, my name was it was never going to happen, but my name was kicked around for SG, and it would have been a great job to have, but I don't have the pedigree for it because I didn't clerk on the Supreme Court, and I've only argued one Supreme Court case, which I won 8-0. And I ultimately ended up being slotted for another job. But in prepping for that, I had a friend who was a former assistant solicitor general, and he basically told me about this issue back then, that it's a real issue it was an issue during the Obama administration, and it was going to be an issue during the Trump administration, the first one. It became an issue again in the Biden administration, and is now an issue again. It's like, can a district judge, regardless of what the claim is, and regardless of the strength of the case, can one district judge enjoin the government nationwide in one case? Like, what? And that's a fair question. Why should this guy in the Eastern,
makes a good point.
This cuckoo bird in the Eastern District of Texas, get every single important case because they realize, he's always going to enjoin President Biden. And the same is like, why should, the fact is they're losing these cases before judges of all stripes, but the Trump administration has it's a legitimate argument. And even liberals will tell you this. Yeah. There probably should be some limits, but no, it's hard to say what those limits will be. But that being said, the important thing, the reason why it's important to talk about this is so that people understand that if the government gets the relief it seeks in the Supreme Court, it's not going to be because they think birthright citizenship should be denied to people who are born in the United States. It's going to be on this ground, and it's not going to overturn the substance. And secondly, the fact that the acting Solicitor General did not take up the meat of the case to the Supreme Court shows you, I believe, I think it's a good litigation judgment. They don't want to lead with their chin.
Yeah.
They don't want to, if they go up on the whole thing, they're going to get slapped down. So they're taking their shot on the narrowest possible grounds, and then they're going to try to slow the case cases down as they go up in the regular course, because this is just on expedited preliminary injunction. There have to be, there have to be permanent injunctions, and then there have to be full-blown appeals. It could take a couple of years to actually get the substantive issue up before the Supreme Court, and who knows what will happen between now and then. Does that make sense?
It does make sense. It does make sense. But I guess, so still, then they're not going to overturn birthright citizenship anytime soon. I
don't even think this Supreme Court will buy it. Maybe you get, because the theory is just by a couple of fringe law professors here and there. It's basically like it's kind of like you're in it's like being in John Easton land on the election and on the electoral college. This is fringe stuff. And, and it's something that I think you could probably find a lot of Federalist Society type law professors rolling their eyes at this the same way, you had Federalist Society law professors basically saying, oh, sure, President Trump engaged in insurrection. He's ineligible for office. And that argument came from a couple of Federalist Society law professors. So I think they're going to lose this one. I think, they are going to lose a lot of these appropriations cases. They're going to lose these reduction in force cases. They're going to lose these cases. I think they're going to lose these cases where they're basically punishing students and trying to deport them without due process on the basis of speech. If they can show that they were engaging in some kind of terrorist activities or illegal activities, but they still got to have process. They're going to lose the Perkins Coie case. They're going to lose what else? I got this whole list of things that I think they are losing, or they're absolutely gone. Oh yeah, they have these more than two cases involving the scope of the January 6th pardons, where they're saying, the government, for what, I don't know what reason, why did you want to do this? They're taking the position that not only did the pardons issued by the president cover crimes committed on January 6th, but other crimes for which they were arrested on January 6th because of outstanding warrants that they committed in the past that had nothing to do for crimes that had nothing to do with January 6th, which is crazy. And two district judges, one here in the district, Judge Chutkin, who you may remember.
I do.
Was it Judge Chutkin?
Chutkin gets a lot of stuff.
Well, no, all these judges get a lot of stuff because it's like, there are only a certain number of them, and there's a lot of illegal stuff going on. Was it Chutkin? I don't know. It was, and a judge in Tennessee got it too. And just think, oh, come on. If you want to pardon these people for this other stuff, write a different pardon. Issue another pardon. And so they're losing those. Does the pardon
cover the stuff that they do going forward?
No, it can't.
It's just narrowly for.
It only covers shit they did on January 6th. Basically, that was the scope of the pardon. And it's not. Not that he wouldn't pardon them for engaging violence on their behalf again. I'm sure he would.
Since you brought up Mahmoud Khalil, we talked about this. JBL, Tim, and I kind of did this on the next level, and but I was interested in just what you thought about it, especially because, to your point, this was actually my position as well, which is if you show me something that he was communicating with terrorists or some other way that he violated the law.
Right. And you complied with the procedural processes that you have to comply with to take someone's green card away.
Yeah.
Because a green card, when you get something from the government, even if it's a privilege that the government doesn't have to give you, the government can't just take it away. Saying, sorry.
Sort of the part about America that's great. It's why people want to be here, is that you can't just go around doing take backsies.
And you certainly can't do take backsies on the basis of the fact that he's saying river to the sea or whatever he's saying. Okay. You may disagree that Palestine should be free from river to the sea. And most people, I think, rightly do, although they may not agree in carpet bombing Rafah. You can't punish somebody for saying that, expressing that viewpoint, even if they are not a U.S. citizen.
Yeah,
because the First Amendment covers everybody within, here.
So people like Megyn Kelly, there's these people that are arguing that it's not a First Amendment issue. And I actually don't, unless, because as best I can tell, right, they are trying to do this under a statute that allows the Secretary of State to say that somebody's a security risk to the United States. However, they have not demonstrated that, as
Correct.
best I could tell. And they also say explicitly he's broken no laws. And so I guess I don't see how this is anything but and look, I don't actually, I disagree. Like, as JVL says, and this is very much true for me, his politics are not my politics. In that, obviously, I would spend a lot of time, if we had the time, I would spend a lot of time talking about why, like, I both am against carpet bombing and sort of the humanitarian crisis that is happening in Palestine.
Right.
While also generally taking Israel's side on their right to defend themselves and certainly to exist.
And the right to exist.
And so, yeah. And so anyway, so the complications of all that aside, but I am and have always been, I'm not sure anything drove me to conservatism more than being sort of an absolutist on free speech. Like, I love America's free speech laws. I think it is deeply, I've always been one of these, like, I will disagree with what you say, but I will defend to the death your right to say it.
Right. Absolutely. It's like the old, I think it was slogan of the ACLU, freedom for the thought that we hate.
Yeah.
Okay. Because you don't know when the shoe's going to be on the other foot. And,
that's right.
To use a terrible metaphor for that, but you don't know. It's like everybody has to be able to say what they want to say and not be punished for that, unless it basically, encourages violence or is conspiring to engage in a substantive illegal act that goes beyond speech. Like,
and look, if you want to kick kids out,
robbing a bank. Right.
Yeah, you want to kick kids out because they're occupying buildings illegally on campus, or certainly if they are threatening, like there was instances of like threatening Jewish kids, like something,
and they're convicted of a crime, then I assume that there's some basis for that. And if somebody actually is a true security threat, and
which is fine, just show your work, guys.
Right, show your work and comply with the statute. And, if you're saying somebody's engaged in terrorism, you got to show that. And it was actually, this goes, the fact that the government has to do that procedurally goes back to, McCarthy era days, where basically the government was just saying, oh, security risk, blacklisting people and doing things. And the government said, and the Supreme Court said, no, you can't do that. You can't just utter the word security risk. Okay, you can't just pull somebody, even with security clearances, you can't do that. You have to at least show your work a little bit, I think. Well, maybe not with security clearance. That's a whole separate issue. I should be careful there. But again, this goes actually, and again, relates to the Perkins Coie case, because the government was resting very, very heavily on national security and the president's supposedly infinite prerogative when it comes to national security. And interestingly, the government, which was gaslighting the court, I went to this hearing, which I was so glad that I did. In the Perkins Coie case, they were, the judge actually mentioned as an aside, and you got that case up in New York with the Columbia student. He goes, well, there's a lot of evidence behind there that has not been made public. And he's like saying, maybe there is, but show us. I mean, if you don't actually show us and tell us what you've got, even a little bit, it's like McCarthy saying, I have a list.
Well, yeah, and this is where, I'm sorry, guys, just trust you isn't good enough in this.
No, because these people with the president of the United States is a pathological liar. And I think frankly, this proceeding before Judge Howell in the Perkins Coie case, he's got lots of liars working for him, because the guy who was arguing for the government was gaslighting the judge. And the judge is like looking at him like, but again,
it's all slippery slope, boiling frog stuff, right? I mean,
right.
This is a question for me. They are doing, I'm watching something that I think is actually quite precise in its calculation, which is go after USAID and foreign funding first, because it doesn't impact Americans in this direct way. Like you don't have time to explain soft power to people right about now. And so like you can dismantle USAID right out of the gate. Go dismantle, like the war in Ukraine, Americans,
what's Ukraine?
They're going after stuff. And by going after Mahmoud Khalil, they're also taking on somebody that puts, even if you're a big free speech advocate, where it was easy to do that before, but now it puts your values in tension, right? Where you're like, okay, but I'm not on this guy's side politically. Like, I don't like what he is saying. I'm against it. So it puts you in the position of defending speech you really don't like, where that you don't want. But if you value free speech, and America does, America puts the value of free speech up very high. We hold it very high.
And they're also picking on people who can be easily demonized.
Right. So,
who they like to demonize. That there's a whole bunch of, there's some cases about, the ban on trans people in the armed forces. Trans people's
another one. So this is to me very precise, very calculated,
very about fascistic.
Going after people that maybe the majority aren't going to rush to defend for a variety of reasons, but that lays the predicate. It's that old quote.
Yeah, it's like, first they went for the so-and-so,
and so I think that's where we are, and which is why I think it is early. We should be aggressive early.
Then they came for the Canadians, and then they came for the,
the Panama Canal.
Panama Canal,
it's not funny. I don't know why I'm laughing. All right.
It's not fun. No, it is gallows humor, which I believe strongly. I'm
going to do this. I'm going to sneak in this next ad, and then I want to do the Perkins Coie because you've been kind of alluding to it this entire time, and it kind of does tie all of this stuff together.
I think it does.
So let's do that. Okay. This show is sponsored by True Classic. True Classic has premium clothes at an affordable price with best-selling t-shirts, hoodies, jeans, and more, which come in 3, 6, and 9 packs. The more you bundle, the more you save. True Classic shirts are designed to accentuate the important areas like your arms and chest while giving your midsection some breathing room. Their shirts are designed for your best features with a perfect fit. Snug in the arms and chest with just the right amount of room in the midsection. There's free shipping on all orders, 100% perfect fit guarantee with easy returns, and they're trusted by over 4 million customers with over 200,000 5-star reviews. George, you wear some of their stuff because it's and what is it? Do you like how it makes your arms and chest look?
Oh, absolutely, I do. I'm not wearing them right now, but hey, next time I'll wear it. Next week, I promise.
I think a tight black tee. This is also, speaking of JVL, he likes to do a tight black tee. Not for me, but just I think that's what he likes to wear.
The tight black tee for thee. Not for me.
So you get a lot of their clothes. I give them to the dudes in my office who wear them, and they look terrific. They look great. Very handsome. So
it's like a uniform now, right?
It is. They're all it's probably illegal for me to tell them what to wear, though. I don't know. You'd have to check with
Longwell's Army doesn't have.
I don't make them wear them. I just offer them, and then they do, and they look nice.
Isn't that coercive?
I don't know. It's a good question.
It seems to you because you're their boss. I'm gonna bring a class action against you.
Okay.
Yeah.
God, no good deed. I swear.
Do you have HR?
Yeah.
You even big enough to have an HR? Does Bulwark have an HR?
Yeah, man.
No, I don't
Everybody's got HR. Okay.
My microphone doesn't work. I want a new microphone.
You don't get HR. Whether you're bundling up for the cold or getting ready for spring, level up your style with clothes that actually fit right. Just go to my exclusive link at trueclassic.com/askgeorge to save. That's trueclassic.com/askgeorge. Shop now and elevate your wardrobe today.
Shop now and forever hold your peace.
Shop now. Reading ads is not so easy all the time. No. There's a lot of S's in these ads.
Particularly with me making wisecracks.
You do. Then you joke during them. Yeah, I'm trying to be a pro here. All right, let's do Perkins Coie, which Coie. I
got it wrong last week, and we got a lot of listener objections to me saying Perkins Coie. I think it was on this podcast.
Somebody has written in my notes Coooe. Coie.
Very good, Coie. Yes, I learned that because I mispronounced their name last week on this podcast.
All right,
but then I got it right. I did. Yeah,
you did it. You got it right other places. Good. Well, yes. you and JVL talked about Trump's executive order targeting them, Perkins Coie.
Yep.
You talked about your disappointment and Big Law's failure to push back against these law firms, the attacks on these law firms.
Right.
But since then, Perkins Coie filed a lawsuit against the government, calling the executive order an affront to the Constitution and our adversarial system of justice, which sounds about right. And on Wednesday, the district court judge issued a temporary restraining order in the case. That's good. And then another law firm, Williams and Connolly, is representing Perkins in the lawsuit. So what do you think? Now, are you starting to feel like maybe a little better? Like, are other firms going to show some spine and jump in and represent like amicus, join up?
My feelings are mixed.
Okay.
And let me explain why. First of all, I just cannot say enough about what Williams and Connolly did in litigating this case thus far. And I cannot say enough about how the district judge handled it. They made a perfect argument. They wrote a terrific brief, Williams and Connolly did, and then the judge handled the argument. Judge Beryl Howell, who has handled quite a large number of the important cases. She was chief judge until last year of the District of Columbia U.S. District Court. She was magnificent. And I got to say, the government lawyer, it was very, very interesting who the government sent and the kinds of arguments that he was making. The government sent as its principal advocate, standing up at the podium before Judge Howell, a guy named Chad Mizell. Chad Mizell, normally that you'd expect the Justice Department to send in an important case involving civil litigation, it's at head of the civil division, which is a job I actually could have been nominated for, and then I decided I didn't want to work for Shit Show 1. Mizell is the chief of staff to the Attorney General. You never see the chief of staff to the Attorney General argue something in court as the chief of staff to the Attorney General, because that's not the chief of staff's job.
Right.
The chief of staff is to be chief of staff, which is to make sure, to control the paper flow to the Attorney General and help deal with the directions that the Attorney General is giving to deputy attorney generals and assistant attorney generals, and making sure that, dealing with, frankly, scheduling of the attorney, basically be the right-hand person. It's an administrative job. They couldn't find anyone else. They had to find a dyed-in-the-wool Trumper. Interestingly, I looked him up after, and his wife is a maybe this is apropos of nothing, is a district judge in Florida who was appointed during Trump 1 at the age of 33 and was found by the ABA to be not competent to be a federal judge. I mean, not that the ABA gets it all right all the time, but 33 seems a little young and inexperienced to be a federal judge. Okay. And so he's a political guy, and he was smooth in a very smarmy sort of way. And he was gaslighting the court in lots of different ways, like pretending, the Williams and Connolly, on behalf of Perkins Coie, presented some evidence in the form of an affidavit from its managing partner saying that, for example, this executive order, to go back to what the executive order does for it, makes findings that Perkins Coie can't be trusted because a long time ago, partners who are no longer there, Mark Elias and this guy, a guy named Sussman, did work for the Democratic Party, and the Sussman, commissioned Fusion GPS to do research, and that led to the Steele dossier. Anyway, they're saying that Perkins Coie, all of its lawyers, even though the lawyers that Trump has a problem with are gone, are a security risk. And as a result, the government shouldn't deal with them. Federal officials should not engage with them. They should inquire of people who are doing business with the government whether or not they, the contractors, are doing business with Perkins Coie. And they also say that Perkins Coie, each federal agency, should be making rules about whether to let Perkins Coie attorneys into their buildings, and that would include the GSA and federal courts, which is crazy. This is basically a ticket to destroying the law firm, because,
hey everyone, thanks for watching the show. If you want to catch the rest of this episode, then go become a Bulwark Plus subscriber. The link to become a subscriber is right below here in the episode description. Click on that, become a Bulwark Plus subscriber, catch the rest of the show, and support all the great work we do here at the Bulwark. Thanks, guys.
Well, George Conway, he's a man with a plan. Got to sit down with Sarah Longwell, take a stand, explain all the legal problems they're piling high. With Donald Trump, oh my, oh my, oh my. He said, Sarah, let me break it down for you. There's obstruction of justice, corruption too, the legal tangles and troubles, they're growing fast. It's a storm that's gonna last and last. Oh, Conway, tell Longwell all about it. Those legal problems can't live without it. From the emoluments to the Russian ties. Oh, Sarah, listen close.